You've started your medical malpractice case against your doctor whom you believe was careless. A medical expert has confirmed that the doctor was careless. And now, after starting your lawsuit, the defense calls your attorney and says, listen, we want copies of your client's medical records. Please send them over immediately. Do we have to do that? What happens if contained within your medical records is damaging information to you, the injured client, the injured patient? Do we have to still disclose that information? Can we remove that damaging information from your medical record before we send it over to the defense? You want to know the answers? Come join me for a walk along the beach as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, when you start a medical malpractice case where you have sued a doctor or hospital staff claiming that they were careless and that carelessness caused you significant harm and injury, the defense will want to see what medical records were involved in your care and treatment. By law, in New York, they are entitled to receive copies of whatever records we have obtained in order to determine that you do in fact have a valid case. Now, in case you don't know, prior to starting any case, any medical malpractice case in New York, we have to obtain your medical records and we have to have them reviewed by a medical expert. That's a requirement. And the only way we are actually permitted to go ahead and start a lawsuit on your behalf is if our medical expert confirms that you do have a valid and meritorious case. In that instance, now we go ahead and file the lawsuit. Great. Now, a few weeks or months later, the defense turns around and says, okay, we now represent the various people whom you have sued. We would like you to give us copies of the medical records that you obtained in order to reach your conclusions that something was done wrong. And now, prior to that, during the time that we were evaluating your case, it turned out that as I would scour through the medical records, I found information in there that was very damaging to you. Very damaging. And it was so damaging that you and I had a conversation about it. And I asked you lots of questions about why and how this information appears there and the reasons that surrounded this damaging information. And now I made a note of that. As your case progresses through the litigation process, there will be a time when the defense will have an opportunity to question you about the claims that you are making and about the injuries and damages and limitations that you have because of this doctor's wrongdoing. Now, and I make a note of that because it will remind me to discuss this with you again as I prepare you for that pretrial question and answer session known as a deposition. All right, so let's get back to the question I raised at the beginning of this video. What happens, though, when the defense asks for copies of your records, and I know for a fact that the damaging material, the damaging notes in that record is contained in the record that they have now asked for? Can I ethically remove that portion of the hospital chart, of the medical chart, before I turn it over to the defense? The quick answer, the short answer is absolutely not. I cannot do that. Why? Because that's improper. Not only will the defense ask for copies of your records that we obtained in order to evaluate your case prior to starting your lawsuit, but the defense will also ask for permission slips, known as authorizations, to go straight to the doctor, to go straight to the source, and get the records directly from either the hospital or the doctor's office or other places. So they will have the ability to go ahead and get them directly from the source, which they are entitled to do, and they're asking me for a copy as well. If I were to remove certain records from our particular version of the record, and then they get copies directly from the source, they will go ahead and then compare to see whether or not they are full and complete copies. They're going to look at it and say, hey, Oginski only gave us 512 pages of this chart. He says it's a complete chart. But yet we asked it directly from the hospital, and guess what? There's now 815 pages. I don't understand. How are there 300 pages missing from Oginski's chart? And now they begin to do some detective work. And what we never want to happen is for them to come back and say, hey, you were given the full complete chart by the hospital. We have confirmation by the hospital that you received the full chart, the 800 plus pages, but yet the only records that you turned over to us contain 512 pages. How do you explain that? We want the other records. And now what has happened? What's happened is we've created a legal issue that could have serious repercussions. We never want to be in that position. If there is something damaging in your medical records, rather than trying to hide it and not disclose it? In my opinion, the better practice is to go ahead and disclose it, to fully disclose it, and there are no secrets. We can deal with it. We can manage it. We can address and explain away why certain things appear in the hospital chart and how it was that this damaging information came to be in the chart. And then we can try and attack it to see whether or not it truly is related to your medical care and treatment that you received by these doctors and the hospital. There may be certain instances where that information has no bearing whatsoever on the treatment that you received. And therefore, nobody should pay any attention to it. Why? Because it has no relationship whatsoever to the claims we are making or to the damages other than credibility. So, if it turns out that we disclose all those details, we give them the full chart, and now when you are asked during your pretrial deposition, you are asked questions about this damaging information, you freely go ahead and answer those questions. You freely go ahead and explain why that information is appearing in that record, and now you go ahead and explain what led to those circumstances that now this horrible damaging information is there. In my opinion, it is a much better strategy to go ahead and deal with it head on, to accept it, to admit that it's there, and to acknowledge it, rather than to try and hide it and keep it away from the defense, because they're going to find out about it anyway, one way or another. And if you try and hide it during the course of discovery, you are opening up a huge can of worms that could have significant legal repercussions, both for the attorney and for you and your case. Let's say he was arrested for DUI and now came into the hospital, and now there's a question about a failure to diagnose lung cancer. Now, the fact that he was DUI or arrested at the scene plays no part in whether or not this patient had his lung cancer timely and correctly diagnosed. Right? But the defense will certainly try and use that information to establish that this guy doesn't have credibility, that he should not be believed. Why? Because here's a guy who violated the laws of the state of New York. He was driving drunk. He was impaired, clearly impaired. He was over the limit. Okay, that's all true in this hypothetical scenario. But what does that have to do about the hospital staff failing to timely diagnose and treat his lung cancer? The reality is, it has nothing whatsoever to do with it. But if you were to try and hide those details about the circumstances that led you to the emergency room in this hypothetical case, now you're opening up a huge can of worms that you certainly don't want to deal with. It's not necessary. There's no reason to create that problem. And you simply deal with it head on. And we discuss different strategies in which to approach that. And in my opinion, at least in this hypothetical scenario, the approach is, yes, I did something stupid. I now have to pay for it. And as a result of that, I wound up in the emergency room. Okay, now let's talk about what happened in the emergency room. I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.